Hey, Legal Rebels, this is Tom Martin. I'm the founder of LawDroid, and this is my podcast, LawDroid Manifesto, where I interview legal innovators about how they do what they do. In this episode, I interview Jayne Reardon, partner and general counsel at Fisher Broyles and former executive director of the Illinois Supreme Court Commission on Professionalism, whose career has been dedicated to helping lawyers be the best they can be. Welcome to the LawDroid Manifesto podcast. I'm Tom Martin, your host, and I'm thrilled today to have Jayne Reardon on with me. She's a legend, and she has a great career of working at the Illinois Supreme Court Commission on Professionalism for 15 years. Now she's at Fisher Broyles, and before that, she's been a trial lawyer. She's won the Women of Legal Tech Award. She's won the Legal Rebel Award, and just recently in 2023, the Professional Responsibility Award. So she has a number of awards, and there's more that we'll also talk about. And so she has really shown the light on ethics and professionalism, and I'd love to talk with her today a little bit about that, but also her origin story and how she came to be where she's at now. And on that note, Jayne, please tell us a little bit about what you're doing now.
Well, first, thanks for having me, Tom. I really appreciate the opportunity to chat with you and be part of your legacy as you're building it going forward. I came to the practice of law never even knowing a lawyer. My parents and grandparents and nobody that I knew was a lawyer, but I was very much attracted to it in college, studying a constitutional law course, a business law course at the college level really intrigued me. And so I went on to law school. I graduated from Michigan Law School, where I was from, in the Detroit area, and then started my practice in Chicago as a trial lawyer. And I loved trying cases. I was in the civil. It was a lot of insurance defense, which got me in the courtroom early, small matters, which now, of course, would probably never go to trial. I think the first case I tried had $50,000 at issue. It was a car accident or something like that. But you got to get your feet wet at a very young age. And I did enjoy that a great deal.
That's awesome. I too had that early experience where you get kind of thrown in the water and have to learn how to swim quickly. I think it's invaluable.
Yeah, I agree. It was scary, but really invaluable.
I want to know a little bit more about how you grew up, where you grew up. You said in Detroit. Where in Detroit did you grow up?
So on the east side of Detroit, St. Clair Shores, if you're familiar with that, it was, pretty middle class. I have two older brothers, two younger sisters. My dad was a surgeon, and his parents immigrated from Sicily. And so he spoke only Italian, worked his tail off, and graduated from Wayne State University Medical School at the age of 21. Very smart man, instilled in all of us a love of education and hard work and work ethic. And I attribute those traits in myself to him and the way we were raised, growing up.
And if I remember correctly, your dad's surname is Rizzo, right?
Rizzo, yes. And for a while after I married, I used Jayne Rizzo Reardon, but I found that when I was on the phone, people would say it just was a bunch of garbled words in my mouth that didn't come across. So I chopped the Rizzo off, but it's still there in the R.
That's right. Well, it always makes me think of Greece, right? Rizzo from Greece.
Oh, right.
Yeah. Okay. One thing I like to do with everyone I talk with is, was there anything that in the environment, in your family when you're growing up, because we know that the trajectory of your career was towards ethics and professionalism. Like that's been a huge part of your career. Was there anything that inspired that in your childhood? Like, was there something that pushed you in that direction, or was it just an interest that came up, let's say, academically later, when you went to law school?
My interest in ethics and professionalism actually came about while I was a trial lawyer, particularly my interest in civility. I remember vividly, I was very aggressive. We were taught to be very aggressive trial lawyers, and I could do that. But I felt it took a toll on me year after year. And I remember one time, like it was yesterday, but it really started me thinking about where I wanted to go with the practice of law. I got in a discovery dispute. It was an insurance coverage issue. And I remember, this is back in the day when we had phones attached by cords on our desks. And I said something like, "I'll see you in court then," screamed it and slammed the phone down. And I just felt awful. I thought, this is not the way I really want to comport myself. And I was overly aggressive. But at that moment, I looked up, and knocking on my door jamb was the partner next door, who gave me a thumbs up. And the juxtaposition in that moment was I needed to choose. Do I want to continue down this aggressive trial lawyer path, or would I be more happy if I changed directions? And I think that was kind of the beginning of me looking at, are we really serving our clients in the best way by engaging in these aggressive tactics where we get into the boxing ring and hide the ball and take a shot and glance? Are we really trying to problem solve, or are we running up fees? Are we serving some other ego that really has no place in the higher purpose of why I was attracted to the law, which is to do something good, because the law is the bastion of, our democratic republic, and people need lawyers to be their voices, and all of those things. I just was starting to think, no, I gotta make a change.
That's a great story. I could see how that would stand out as kind of like a two roads cross, right? Like where you have to make a choice between those two things. And I completely feel for where you're coming from, because I did the same, I had the same experience when I litigated. And I think for you to take that and to make, a career out of it is amazing. I think the work that you've done with civility, right? The Illinois Supreme
Yes.
Court Commission is really something that I think should be duplicated in a lot of other states.
We're very lucky that the Supreme Court established the commission at a time when other focus of other Supreme Courts was on the issue of professionalism. And they funded the commission out of an allocation from the attorney registration and disciplinary fees that lawyers pay every year. For whatever reason, other state Supreme Courts did not follow suit. So we kind of stand alone in that regard.
I think your point too about how there's this interesting confluence between the billable hour profit motive and that kind of like sharp practices, that they kind of go hand in hand. And, whether or not that's intentional or it's just happened that way and it's become a cultural thing that that we get foisted on us. It's an interesting point there. But I do want to ask you that, okay, so now you have this kind of choice to make. And at that point in your career, you did make a choice for something different. And tell us a little bit about that.
Yeah, I was thinking about this over a matter of months, frankly, years, but what happened was when I was pregnant with my third, we have 4 children, and I was late at the office, like real late, 11 p.m., midnight, hadn't seen my toddlers in 4 days because we are working long hours on trial, going through motions in limine and jury instructions. I thought, I can't, I don't want to go on. And right after that trial, an opportunity arose for me to become a review board counsel to our Illinois disciplinary system. And I took that job, which was part-time, done at my home, except for hearings once a month. And it actually allowed me to really study how lawyers get in trouble, what the rules of professional conduct provide, why they are the way they are. And so it piqued and fueled my interest in attorney ethics. So that was a great move that really, I was just open to it, but an opportunity came along and I grabbed it, and it was wonderful.
Well, one thing I want to ask you, because we did talk about this before we started recording, like, do you feel that at that time, and the context is the early 90s, I believe that we're talking about, that it
Right.
was was it something that was forced on women lawyers, that they had to make choices in order to have a work-life balance or have a family, that they would have to make decisions about whether or not to be in a litigation firm or not?
At that time, I think to be a trial lawyer, you had to be willing, male or female, to drop everything when you were on trial and the several weeks before leading up. It's all consuming. It's exciting when you're in the courtroom. There's a lot of adrenaline flow, and it was a lot of fun too, but it's all consuming. It is not a part-time job. I don't think that's any different now for men or women. If you're going to try cases on a regular basis, whenever you're on trial, you have to give it 100%. What I think has changed from the women I know and the men is there is a greater understanding of the importance of time off, of some work-life balance, of allocating work in a way that can allow people to be productive, but also go away, generally speaking. I think we're in a better place on that now than we were back then. For me at that time, because I saw it as trying cases or not trying cases, I didn't explore a lot of other things, and I didn't see a lot of other options for part-time back then, and I certainly do now. Part-time, remote, hybrid, all of these things can help women and men have more work-life balance. So I think we're in a healthier place as a profession now than we were in the 90s.
Well, thank God for that. Um,
Can't be any worse than it was back then.
so the work at the Attorney Registration and Disciplinary Commission, um, a little bit about that. What kind of stuff were you doing there?
So that was straight up discipline of lawyers. If lawyers are found to violate the disciplinary rules, they're prosecuted. In all states, they have a similar system where bar counsel, they call it in some states, will bring a complaint against a lawyer, and it goes through a litigation process. A hearing is had. Here in Illinois, it's before 3 people, 2 lawyers and a lay person. An opinion or report and recommendation is issued, either finding violations of the ethical rules or not, and recommending sanctions if rules were violated. then the respondent lawyer has a right to appeal. I worked for the appellate division, if you will, of our ARDC. And so I handled the record on appeal, summarized the issues. I was basically a law clerk to the review board, which also sat in 3-person panels of judges and retired judges. And then a report and recommendation was issued. I wrote the first draft. It was finalized and it went up to the Supreme Court. In every state, I believe it's this way in every state, the Supreme Court is the one that actually issues discipline for lawyers, a suspension, take their law license, or no problem. So the cases were sometimes the voluminous in records, a couple bankers' boxes of records. Very interesting for a while. But after a while, lawyers get in trouble for the same handful of rule violations. So it's not the most intellectually challenging. And then when the Supreme Court created the Commission on Professionalism, which was another commission created by the court to be more proactive and promote professionalism and civility, I jumped at the chance to join that organization at its very beginnings and then rode that up, built it up. It was a lot of fun. I was there for 16 years.
I'm curious, when you were working on the board council, is there any story that sticks out? Like, is there one that sticks with you about something that happened, some disciplinary matter that, was a memorable one?
Well, Tom, I'm from Chicago, so there's a few lawyers who get in trouble in this state. But I don't really want to go into that. What struck me is how prevalent just a failure to follow up and have systems in place tripped up lawyers. And over and over again, failure to communicate, missed deadlines, those sorts of things, which, nowadays, it can all be automated and calendared and reminded, people can be reminded and hopefully, and it's true, there are fewer and fewer disciplinary cases for those kinds of things.
So I think it's interesting, like the transition from working with, the review board and then going to the commission on professionalism, like one going from like reactive to proactive, and that actually getting ahead of things and saying, okay, we don't want you to do this kind of stuff, and here's what you shouldn't be doing, and here's the better stuff that you could be, incorporating into your practice. And I know that for 16 years, I believe it was 3 as deputy director, and then the balance of it as executive director. I guess what are some of the things? What are some of the programs that you put out there for lawyers to learn how to behave better, or things that they should be including in their practice to communicate better with their clients?
So at the same time as the commission was established was the first time Illinois had a CLE requirement. So our commission was involved in professional responsibility education. And very early on, we worked to have technology and efficiencies and those sorts of programs qualify for CLE, which at that time, believe it or not, we're talking about 2006-ish, many lawyers were like, I don't need to learn anything about a computer. I've been doing it this way my whole life. And I traveled the state quite a bit, and I saw the disparity in resources that lawyers were leveraging to do their jobs. So So we pushed professional responsibility, CLE, for technology, project management, those kinds of things. That really intrigued me, and I became convinced that lawyers needed to, and this is before we were required to by a comment to the model rules, incorporate technology into the practice of law. So that was kind of a focus, and that got me thinking about the future of the profession and how we could proactively support lawyers to get there. Another program I'm particularly proud of is a statewide mentorship program, which we gave professional responsibility CLE credit to. And I think mentorship is really underrated and so important. You and I, started practicing law in a law firm. I went down the hall and talked to people. Sometimes I would ask 3, 4, 5 people related questions because I didn't want any one person to know how really dumb I was. And inadvertently, what I did was create a bench of mentors. And it was fabulous, and that people that I could go to and ask questions. I worry about mentorship now that so much is being done virtually. How are we mentoring? What are we passing along in terms of those principles of professionalism? How do we really act kind of things in certain situations, which you're not going to read about in a book necessarily? So I think mentorship is key, and it's continuing in Illinois and other states as well.
Those are really great initiatives, and I completely agree with you about mentorship. And you're totally right. Given things being more decentralized now, more virtual, that's something that seems like it might be at risk. Do you think that maybe there's a different way to handle it now, that since virtual representation, remote connections like we're having right now, are there new ways to get people more involved and to foster mentorship?
Absolutely. And we originally in the state of Illinois only allowed credit, CLE credit, for in-person mentorship meetings. And once the pandemic hit, we allowed virtual, and we continue to allow virtual mentorship. The reality is we have to do more virtually because lawyers are spread thinly across. We have 102 counties in the state of Illinois, and many of the counties aren't licensing new lawyers, or if they are, it's 3 or 4 for the whole county. So there's a need for virtual mentoring, just like there's a need for, in my opinion, virtual provision of legal services to reach people who may not have access to a live human lawyer.
So, okay, those were a couple of the initiatives at the Illinois Supreme Court Commission on Professionalism. Were there anything other initiatives that you worked on that maybe are making you believe are making an outsized impact?
We did do education and interaction with judges. And I think that the more lawyers and judges interact, the better for our profession, because judges were lawyers once, and judges, particularly Supreme Court judges, justices, have the responsibility for regulating the legal profession. And so I very quickly realized, and I didn't really understand this going into the Commission on Professionalism, how important it was for lawyers to understand where the ethical rules come from and how they apply, and what role they, as well as justices, can have. we have an awesome responsibility in our profession because we're what we call self-regulated, right? Well, you know, the people who are self-regulated really bear much more responsibility to make sure we're not regulating in our own self-interest. And so part of what I got involved in at the Commission on Professionalism is really studying some of the regulations that govern the practice of law and some of the states that were exploring modifications to the regulations and some at the national level as well, to account for the fact that, yeah, our ethical rules have existed since 1908, in large part unchanged, but the practice of law, our society, the needs of the public, the complexity of laws, treatises, regulations, ordinances has ballooned. And we really ought to be very carefully and deliberately looking at how are we regulated and are we doing the best we can to make sure that we are serving the public. That's what we exist for as a profession. And I've come to believe that there is a relationship between the way we are regulated and the access to justice gap. And so I've been devoting quite a bit of time over the last several years to researching and writing on that topic.
And I've definitely heard you writing on that, well, read you writing on that topic and heard you speak about it. The very words that you're saying right now, I know that you've said even more forcefully on stage sometimes.
Just
And
before I got the shepherd's hook to get off.
no, it needs to be heard. And I think now, maybe we have some tools to actualize it, to make it possible to scale the kinds of services that people need, and also to surface their ability to understand what services they need, because a lot of times people don't know.
They don't even recognize a problem might have a legal solution. That's what research show. And so why would they go to a lawyer, if they don't even recognize it as legal? And that's on us. We have the obligation as lawyers to educate the public about their rights and protect them.
So from that, you jumped into being a partner and deputy general counsel at Fisher Broyles. If you could share a little bit about that and what you're doing there.
Yeah, so after a while, I stepped away from the Commission on Professionalism, and I was developing an ethics consulting practice. But a friend of mine who I've known from the ethics and professional responsibility circles approached me about joining Fisher Broyles. Fisher Broyles is a law firm that is what we call disaggregated. There is not a central office. Everybody works from their home state or city or office, or they may establish an office if they want. It's the oldest disaggregated law firm in the country, being established in 2002. Now there's a few dozen. So that model is really expanding. And the whole idea is that we can serve our clients without the debt involved in a bricks and mortar office. And clients, research shows, they really don't want to take time off work, go downtown, park their car, go up into some wood paneled building and find a conference room and waste a half a day to have some lawyer pontificate at them, right? So I thought this was a model that fit with my viewpoint. And so I'm starting along with Anthony Davis, who's been in the professional responsibility space a number of times, a ethics and professional responsibility group within that law firm. And in addition, it turns out that just as I was going over there, the firm experienced a split, and they needed help in the GC's office. So I'm Deputy General Counsel. I handle the litigation claims and circumstances for the firm, helping the General Counsel and others in that office. So there's a wide range of problems. They're very interesting. And it's challenging, and I'm having a ball. It's really fun.
It sounds great, but it also sounds like you have a lot on your plate.
Yeah, but you know what, Tom, for like maybe it was a year and a half when I was on my own, Jayne Reardon LLC, I was a little bored, I have to say. And as I said to my husband, you know, if I don't do something more, I might actually have to you know, clean out the garage and my study and pick up things, and I'd much rather work. So
Yeah, I hear that. You know, I myself have a few balls in the air, and it does keep life interesting.
yes, absolutely.
So with that, you know, kind of foundation about your journey, I'd love to get into some of the topics that I know that you've written a lot and talked a lot about, and then kind of take it from the standpoint of the topic du jour, artificial intelligence. Um, for example, you've written a bit about UPL and also about non-lawyer ownership. And I'm curious, now that we have generative AI and it makes it possible for basically a chatbot to serve up answers to questions, whether or not that crosses the line between advice and information, that's kind of an open question right now. Do you think it should be considered advice? Like, what is that the question we should be asking, or is the question really about how many more people we could serve? Um, I'm curious as to what your take is on what's possible now.
Okay, I'm going to take a step back. I forgot to tell you about a program that we started at the Commission on Professionalism, which was to go into various courthouses around the state and train up staff, you know, docket clerks, law clerks, various people who worked in the courthouse. And we did these professionalism trainings numerous times in various courthouses. A huge part of those professionalism trainings was to reinforce what they could do and say to citizens who walked into the courthouse. They could give information, but not advice. How do you define information? How do you define advice? You're allowed to say X, but not Y. And it was very frustrating because if you put yourself in the shoes of the average person who's walking into court with, you know, what do they got? You know, a ticket or an eviction notice. They just want to be told some, you know, they don't know whether it's information or advice. And I think that that distinction, which still exists in the UPL rules and statutes in most states, must be reassessed. It makes no sense in the current climate when your average person can ask a generative AI tool these questions and get answers. They want answers. They don't care if it's information or advice. If you put yourself in the consumer's shoes, they want answers. And I think we're getting there because increasingly, you know, you've got generative AI tools that can really help, but they're being chilled. About the fear of UPL prosecution. I think we are getting to the point, there's been challenges on constitutional grounds and on other grounds that we're going to get to the point where we have to re-examine unauthorized practice of law. If in fact, the philosophical rationale for unauthorized practice of law, rules and regulations is protection of the consumer. How about we ask the consumer what they want instead of
Wow.
just other lawyers, you know? And that is starting to be done. There are a lot of initiatives now. In fact, the Institute for the Advancement of the American Legal System is starting a several-month initiative to bring the public into the issue of regulations. It is very paternalistic for us lawyers to decide that we know best how to serve the public without ever asking them. And the public is going around us. They're getting answers by just going to the search engines. And if we really care about our democratic republic, involves members of the public, helping people protect their rights, we will re-examine and try to figure out how to make this happen. I might have put this in one of the articles you read, but when ChatGPT 4 took the bar exam and passed it in the top 10% of when compared to human test takers, and did it in 6 minutes, there is no more graphic illustration of why and how our UPL laws, many of which are written, it is the unauthorized practice of law for a non-lawyer to do anything that a lawyer typically does. That can't stand. That can't stand. Typically, a lawyer passes the bar exam. Generative AI passes it better than most. So we need a new definition. And I'm not saying we shouldn't protect the consumer, but we really have to be open and honest about what we're doing, and how we can responsibly allow people to access these generative AI tools to their benefit.
Well, as you might expect, I'm 1,000% on the same page with you. I think that, like the concept of UPL and its chilling effect. I mean, if you completely removed UPL, you still have consumer protections in place. So like there's still protections that are for the reasons that we say that we have UPL to protect the public that would continue to be there, so that if there were bad actors, you could still go after those bad actors, but it wouldn't, in principle, be this impediment to free speech, essentially.
Right. And, if I could just address that consumer protection piece. Again, our disciplinary system and our consumer protection system is reactive, complaint-based. It is not proactive. And so many consumers are harmed, but most states don't have a method for assessing that harm unless the consumer complains and the lawyer was found to have exhibited dishonest conduct. Then they get partial reimbursement of their financial losses. That system is not very robust, shall we say, when it comes to consumer protection. And I'm gratified to read in some of the states that are re-regulating or considering pilot programs, almost all of them are incorporating data-driven evidence and requiring people to collect data, seek data from consumers of harm, et cetera. And that proactivity is a new approach, relatively new, for our legal profession, and I think it's really necessary.
I think, like referring to Utah, right, where they do collect information about complaints from consumers and customer satisfaction and things like that to actually track with actual data, not just seat of their pants feeling, but to look at the numbers and see how people are experiencing those services.
Yes, yes, I think that's one example that's going on in Utah. And then there's a few other states that are in the comment period for promulgating pilot programs and of entity regulation in Texas, I believe, and Washington State. And all of the programs are really focused on collecting data and analyzing it on a moving forward basis, and Arizona as well. And that's going to be helpful to other states that might be considering following suit.
So a question that comes to mind that I think you're especially suited to answer, given the fact that you worked on the proactive side with the commission, is if we get away from like the data driven, that's backward looking, right? Because we're looking at customer complaints, we're looking at data of their experience with that company. But how can we what would it look like to have a proactive approach in terms of ethics and consumer protection for some kind of generative AI legal provider? What would it require that that like, let's say it's a LegalZoom, but a Gen AI LegalZoom that's providing information to consumers directly? Would it be that entity would have to certify that it's attended certain like ethics presentations, or that it's has a policy that complies with ethical rules that lawyers normally would follow? Or what do you think that would look like?
That's so fascinating. I think it would have to be multifaceted and probably segmented depending on what segment of the population they're serving, right? I think we're kind of past the one size fits all. And that's why I really like the idea of regulatory sandboxes, or where innovative entities can contribute their perspectives. I don't know enough, and most lawyers don't know enough about the capacity of a generative AI for direct legal services to consumers, and what kind of data they could collect to prove efficacy. I would think at a minimum, they could do surveys proactively, not just wait for someone to complain. That would be helpful. I think that for most of these entities, it would be worth considering having a compliance officer appointed, like is being done in Arizona in entity regulations, because the reality is, then you bring into our ethical rules all the people involved in that entity, involved in that product, that are delivering legal services. And that compliance officer would have the experience and wherewithal to understand the technical aspects of what's being delivered, as well as the ethical requirements, and make sure all personnel, whether they're JDs or not, are in compliance. That's a guardrail that I think could be established pretty easily.
Yeah, I really like that approach. It mirrors something I've been thinking might be a solution, is essentially entity regulation, where you have the company being, ultimately legally responsible, but that naturally there would be some representative of the professional ethics, be it an attorney that is licensed, that kind of promulgates these rules and ensures that the company is in compliance with those rules. But it makes a lot of sense. I mean, I'm not sure what other approach there might be.
Yeah, I'll continue to think about it, because I don't know either. But what we have going now is technology companies are out there delivering information or advice or whatever legal services, and they're unregulated by the state Supreme Courts for the most part, unless they're in some of these model reform states. And it's a shift for the state Supreme Courts to realize their job isn't just to discipline lawyers who violate the ethical rules, but they're actually regulating an economic sector, the provision of legal services. And when you think about it that way, it really shifts at least it shifts my mindset as to how this should be approached, and the gargantuan reset we need to undergo.
I wholly agree with that reset. I think that it'd be a terrible waste if the kind of regulation that happens, if it does happen, which probably will, that it simply like mirrors what we already have and is used as a form of like regulatory capture to just control further this new opportunity that we have to open up access. That would be a shame.
I agree.
Well, fascinating discussion. For the benefit of lawyers that are watching this, and they really take to heart ethics and doing things the right way and benefiting the public and all of that, what are some ways that you would suggest to them that they can follow through with to expand their knowledge, to be better at practicing ethically, that they could use in their daily practice?
One thing I think would be very helpful, especially if lawyers are relatively new to the profession, is join a professional responsibility or ethics and professional responsibility committee of your local bar association or your state bar association. You can stay abreast of case law that comes down, ethics opinions, conundrums, and how it's handled. I have learned a whole lot by joining the ABA Center for Professional Responsibility. I have been members of committees within that organization, as well as the Association for Professional Responsibility Lawyers. We call it April. There's a lot going on in this space, and if you join some of those listservs, you can keep abreast of developments that might be of interest to you. And so I would say start there, and start reading about that, and read about what we fondly call the future of law, or the future practice. It's actually here, and we're just running to catch up with it. But there's a lot of information out there, and I'd be happy to talk to anyone who's interested in knowing more.
So about that, I know that people that are listening or watching would probably love to follow up with you. What would be a convenient way for them to do that?
They can email me at jane.reardon@fisherbroyles.com. Find me on LinkedIn or on Twitter at Jayne R. Reardon. Those are the three best ways to get a hold of me, and or see me at a conference.
Well, I hope to see you soon too.
Likewise.
Do you have any like last words of advice that you might have for the people that are watching today?
Yes, I do. I would say this is the most exciting time to be a lawyer. I've been a lawyer for, I'm not even going to tell you how many, but decades. And the opportunities to work in new creative ways alongside professionals who have complementary skill sets different ways of doing things, technology companies, allied professionals, the opportunities abound. And I think if we open our eyes beyond just the silo of traditional legal education we got in those 3 years of law school and realize, number one, we have to continuously learn because things are changing rapidly on a daily basis, and we can be creative. We will be energized because we can also make a difference. We can make the world a better place. We can provide more people with access to an understanding about their rights, about what the law can do for them, why it's wonderful to be in this democratic republic. And those kinds of things feed my soul. And I think for most of us who went to law school, we did it to try to make a difference. And I think we have the tools right at our fingertips to do so now.
Well, those are wonderful words of wisdom, Jayne. And thank you so much for being on my show.
Thanks for having me, Tom. It was a lot of fun.
And thank you all for watching the LawDroid Manifesto podcast. See you next time. Thank you so much for watching the latest episode of the LawDroid Manifesto podcast. To keep in the loop about upcoming episodes, please subscribe to LawDroid Manifesto and you'll get notified. Thanks for watching. See you next time.